Approval of the minutes. The committee assistant sent out minutes for February 14th and 16th. I hope everybody's had a chance to look at it. Do I have a motion? Representative Neighbor, sorry.
Oh, I'm so glad I just became one. Thank you, Mr. Chairman. I move acceptance of the minutes for both dates, for the 14th and 16th.
Okay, I have a motion by Representative Neighbor, a second by Representative Dodson. Any discussion? Okay, seeing none, all those in favor signify by saying aye.
Aye.
Opposed, nay. Okay, the ayes appear to have it. The ayes have it. The minutes are approved. Our next order of business is action on possible action on House Bill 2167. If I could get the revisor to give us a quick overview, please.
Mr. Chairman, members of the committee, Mike Heim with the revisor's office. I'll stand when we get into the bigger thing, but this one deals with cryptocurrency. There's an amendment on page 2 which deals with any political funds that have been collected by a candidate or candidate committee and were subject to reporting requirements shall not be used in a campaign for a candidate for federal elective office. And then the amendment on cryptocurrency is on page 3, and basically it prohibits the acceptance or the giving of more than $100 in cryptocurrency and requires that it be transferred to cash and so on, and requires the contributor's name, address, and so on. Anyway, that's the gist of the bill.
Okay, are there any questions for the revisor? Okay, seeing none, what's the will of the committee here? I'll entertain a motion on this bill.
Mr. Chair, do we need to move the amendment first?
Yeah, what I've been doing generally is kind of the way that we've always done at this committee. I do a motion, then we have discussion and consider amendments, and then renew the motion. So do I have a motion on this bill? Okay, Mr. Vice Chairman.
I would make a motion we pass it out for approval.
I have a motion by the Vice Chairman and a second by the ranking minority member. Committee, before I open discussion, I have an amendment. Mr. Revisor, if you could hand that out for me. Okay, so what this amendment does is it's being handed out is basically instead of setting regulations for the donation of cryptocurrency to campaign funds, it bans it. So you would not be able to donate Bitcoin or any other cryptocurrency to a campaign committee or a political party or political committee. Kind of my justification here, first of all, the executive director said he was fine either way. And my second justification for this is I'm concerned that some of these cryptocurrencies have very small footprints, and I could envision a situation where somebody donated $100 worth of cryptocurrency and then manipulated the market to make it worth $10,000. And so that's kind of the thoughts there. And with that, I guess I move my amendment. Is there a second? Representative Dodson, and then discussion. Representative Neighbor.
Thank you, Mr. Chairman. I'm glad that you brought this amendment because to me, cryptocurrency and some of those other forms of remuneration or money are still in its infancy, and I think a lot of people who haven't used it or don't know how to use it could be caught up in something they don't understand. We've also seen on the marketplace money be spent that has almost bankrupted a multimillionaire, billionaire. And even though I've never understood it, I think it reminds me of monopoly money. I like having it in my hand, but I can't spend it anywhere. So I am very much in favor of this amendment. I think it simplifies anybody's question. So thank you for bringing it.
Thank you, Representative Neighbor. Representative Collins.
Thank you, Mr. Chair. I was going to use the monopoly money analogy myself, but Representative Neighbor beat me to it. But I just feel like cryptocurrency, like I said, it's still fairly new. And, you know, if someone wants to donate real money, American dollars, and they have cryptocurrency, they can convert it themselves and then donate it as dollars. I think you know, there'd be a lot more legitimacy to that, and a lot better as far as, you know, that way it'd probably be easier for the Ethics Commission that way. They wouldn't have to worry about it. I mean, I don't know, I haven't asked them, but just seems to me like makes more sense.
Okay. Representative Berquist.
Thank you, Mr. Chair. I think the fact that I don't understand it very well is probably less important than the fact that a pretty good part of our society doesn't understand it very well. And at least we don't need to create more questions about our election process and about our integrity by having things for people to ask questions about rather than to have clear confidence in. So I'm in favor of this amendment.
Is there any more discussion on the amendment? Okay, seeing none, I close on my amendment. All those in favor of amending signify by saying aye. Aye. Opposed, nay. Okay, the ayes appear to have it. Ayes do have it. We're back on the bill. Is there any discussion on the bill? Representative Neighbor.
Thank you, Mr. Chairman. If there are no more amendments, I would make the motion to pass out House Bill 2167 as amended favorably.
Okay, is there a second? Second by Representative Underhill. Revisor Heim, did you have something?
I believe there's a technical amendment on page 2, which, if I understand correctly, we would be on page, line 17 through 19, we would delete that, and the new language would continue, but the old language would be deleted. I think this was Mark's suggestion, I believe, in terms of Skoglund, in terms of clarification of what the law is needed. I interpret it as a technical amendment.
Representative, is there any objection to
No objection.
renewing your motion with that amendment?
Mr. Chairman, I would move that we pass out House Bill 2167 as amended and also allow for technical cleanup by the revisor.
And Representative Underhill renews his second. Is there any further discussion? Seeing none, all those in favor signify by saying aye. Aye. All opposed, nay. Okay, the motion carries and the bill is passed favorably. Our next order of business is consideration of House Bill 2391. Do I have a motion on that? No. Oh, I'm sorry, Revisor Heim.
Mr. Chairman, members of the committee, I believe this balloon was, or these amendments were sent out to the committee last evening, but I made copies because I thought it might be helpful. Again, I don't know how thorough you want me to go through this. You tell me, short version or longer.
We'll start with the short version, and then if there's questions, we can devolve into the long version.
Sure. You've seen the amendments before at the meeting last Thursday. There's been some additional changes and so forth, and I will just kind of hit the highlights of where the bill stands. One of the amendments is on page 1 there. The statute of limitations is changed from 2 years to 5 years, and that's a statute of limitations that is used for most criminal statutes. It's used for contracts, it's used for land kinds of transactions and so on. So it's a fairly common use of for 5 years. So anyway, that for whatever that is. The amendments on page 2, the executive director will have the qualifications of what a commission member would have. That's pretty much technical. The section 3 loosens a little bit about who may serve on the commission, not prohibiting somebody that has been served in a political office within 5 years and so on. Section 4 deals with definitions. There's a new definition of agent. It was changed slightly on page 5 there to delete any person with a power of attorney and provide basically in the alternative director, officer, employee, other person authorized in writing to act on behalf of. There's a new definition of coordination and coordinated. It's taken from the Federal Election Commission CFRs and so on, at least partially from that. That's on page 6. There's a new definition of political committee on page 8. The old language is stricken and the new is revised. Not sure I'm the best one to go through the changes, but you've got a new definition on page 8. Page 9, section 5 deals with party committees and political committees, and it provides a kind of a mid-level in terms of a registration fee. The new language is on page 10, each registration by a political committee anticipating receipt of between $2,500 and $1 and $10,001. The fee is $100 instead of the $300. Number 6, or section 6, excuse me, on page 10 at the bottom there, deals with treasurers, and there's a technical amendment where they had to file at one point in time at both the local and state level. This deletes the "in both" language. And the real only change is a language on page 12, which strikes the cooperation or consent and adds the word coordination in line with the definition of coordination. The section 7 on page 13 deals with treasurers for committees and so on. And again, the change, it deals with the language of coordination. There's a new section added, new section 8, which is on page 14 on the right-hand side there, and it provides that every person, it adds an individual in addition that other than current law provides for a candidate committee, party committee, and so on. This adds individual to that series of statutes. The civil penalties would go into the state general fund. That's on page 15. If there's a violation, there's a section 9 deals with legislative session restrictions on fundraising, and there's an exception written in at the bottom of page 15 No solicitation shall be considered a violation if it's accompanied with a disclaimer that it is not intended for lobbyists, political committees, or persons other than individuals. Number 10, or Section 10 of the bill deals with political committees, and it provides that no member or candidate of a legislature shall serve as a treasurer or chairperson of a political committee, subject to the prohibition against coordination between candidate and candidate committee and political committee. Nothing shall prohibit a member or a candidate for the legislature from soliciting funds or for participating in the activities of a party or political committee. Section 11 on page 16 deals with contribution in the name of another. It defines that. Section 12 is at the bottom of page 16 on top of page 17, deals with what you can use your campaign money for. And those new items are listed on page 17. And there's some additional language in there in regard to expenses, compensation of gifts to any volunteer, staff member, contractor, et cetera, provided that the total amount of such expenses, compensation, or gifts do not exceed the fair market value of the services and so forth. The rest of it's been in the bill since the beginning. Section 13, there's a new section or amendments to 254158, which appears as attachment A. So it's the same section of the law that's amended, but there were so many amendments that it was just easier to start from scratch. And this is dealing with the subpoena powers and so on. It now provides that there has to be an application to district court and so forth, and some other procedures, which I can get into if you want. The section 14 on page 20 deals with complaints and filed with the commission. It provides on page 21, any attorney or staff member representing the complainant before the commission shall not engage in ex parte communication with or otherwise advise, represent, or assist the commission regarding members before the commission. The commission shall obtain separate independent legal counsel in the event an attorney or staff member employed by the commission represents the complainant. In other words, if they're bringing the charge, they need to get separate legal counsel. There's some case law that I would say probably supports that type of thing. Anyway, at any time, the person can request, that's a subject of an investigation, can request that it be transferred to the Kansas Office of Administrative Hearings and have them hold the hearing instead of before the commission and so forth. There's a provision for reimbursement of costs for producing records for subpoenas and so forth. Excuse me. Anyway, there's more, but that's
The wave
enough
tops.
unless you want more.
Okay, any questions for the reviser? Representative Berquist.
Yes, after I raised my issue, I discovered my answer. Thank you, sir.
Okay, are there any other questions for the reviser? Mr. Vice Chairman.
Mr. Chairman, Mr. Reviser, on page 21, the notion of, upon the request of the respondent, any hearing held under this act may be removed for hearing before a presiding officer from the Office of Administrative Hearings. So basically that's saying if somebody, rather than going before the Ethics Commission people themselves, they could opt out for one of the established Office of Administrative Hearings people.
That's correct.
That's correct. All right, thank you.
Okay, Representative Howerton and then Representative Neighbor.
Thank you, Mr. Chair. Could you explain the difference to me between subpoena or subpoena?
You should take them.
Thank you.
Subpoena is typically subpoenaing a person to appear. Duces tecum means bring your records. Bring your records, written material. One's the individual, the other is the stuff that you want to look at to review.
Representative Neighbor.
Thank you, Mr. Chairman. As a point of clarification, are we going to have an opportunity to discuss each one of these particular issues, or does that need to go through Mr. Heim?
If you have questions for him of a legal nature while we're doing the discussion, I have no problem with asking him questions as we talk.
Thank you.
Okay. Any other questions for the revisor? Representative Essex.
Just a quick point of clarification. I apologize if I missed it, but wanted to make sure that in this amendment, PACs still cannot coordinate with candidates, correct?
I'm sorry, say again.
Political action committees cannot coordinate with candidates. Is that correct?
Correct.
Is that in this
I believe
amendment?
That's correct. If I'm wrong, somebody in the audience will correct me.
Okay, thank you for that.
Okay, are there any other questions for the revisor? Okay, if not, thank you, Mr. Heim. We kind of got to put the cart before the horse here a little bit. I need a motion on the original bill. What's the will of the committee? Okay, Representative Berquist.
I move to pass out the original bill.
Okay, I've got a motion by Representative Berquist and a second by Representative Underhill. Before discussion, I'll move the amendment. I move that we amend per the amendment that was just handed out. So the origin of this amendment is really to address some of the concerns from the opponents during the hearing. The 5-year statute of limitations aligns it with the criminal aspects of the Campaign Finance Act. The research right before we came in here sent out some work that she's done on other administrative agencies and how they issue subpoenas. And the Ethics Commission would not be unique in having to go to a judge to get a subpoena. But what we did do is the concern was from ethics that they would not be able to get a DA or an AG or the AG to start an inquiry. So now he can go directly to the judge to get the subpoena. We also fixed the issue in this amendment with 5 members. Only 5 members can be from the same party on the commission. That was an unintentional deletion. And then the last thing I'd say is there's been consternation about the redefinition of a political action committee. The reason $2,500 was chosen is if you go to the Campaign Finance Act, if you're spending less than $2,500 in express advocacy, it's not under the jurisdiction of the Ethics Commission. So it was really to align those two numbers. So with that, I've moved the amendment. Does anybody have a second? Okay, Representative Howerton seconds. Is there any discussion on the amendment? Stunned silence. Okay, Representative Collins.
Okay, I just want to mention that the statute limitation change, I was having some big reservations about the 2 years because that's not even a full term for some people, Senate or other offices. So I will be in favor of it because of that change, that amendment.
Thank you. Is there any other discussion on the amendment? Okay, Mr. Vice Chairman.
No, I appreciate the chairman's providing an explainer, which I think all of you were emailed. I mean, some of the, obviously this has been a somewhat controversial bill, or certainly both sides have been very passionate. Yeah, that's probably a good word for it, passionate. But I do see what you've done here is actually, I think, definitely improves the bill and takes out some of the more concerning aspects of it, but keeps the fundamental underlying essence of why we would even be going this direction. So, thank you.
Is there any more discussion on the bill or on the amendment? I'm sorry, Representative Dodson.
I just had one kind of quick question here. When we're talking about a subpoena or a duce tecum, and I didn't read all of what the research sent up, but is it normal for us to have all the committee physically present? I mean, is that the way most of these committees act, or can they do it by WebEx or other kinds of means? It says physical presence in here.
So the, I believe, and I'll turn over to Mr. Heim here, but I believe the original statute says that to issue a subpoena, 7 of 9 commissioners have to vote in the affirmative and in person. I think what we're doing here with this amendment is we're taking the issuing of subpoenas out of the hands of the commission and having the executive director go to a judge, to the Shawnee County judge, to get subpoenas issued. And if you look at the stuff the research sent out, that's not, they would not be unique in that. They're, most agencies, if you're issuing subpoenas for, somebody not, doing cosmetology without a license, they don't have to go to a judge, but there are several agencies, I know like DCF and a couple other agencies do, schools have to go to a judge to get a subpoena.
Well, the reason I was asking that question is on attachment A, about halfway down. It says any vote authorizing the issuance of a subpoena or subpoena duces tecum shall be taken at a meeting where the commissioners are in physical presence.
Mr. Heim.
The way it reads is correct. It takes 3/4 members of the commission to authorize it, but they still have to go to the district court in Shawnee County to
I got that part.
get it done.
Okay, thank you.
Thanks for the clarification. Representative Neighbor.
Thank you, Mr. Chairman. And I know a lot of work has been put into this, but I've been doing some reading on the side and looking at some different things. And one of the articles that I came across was very critical of what is taking place in this bill. Essentially, it takes away the entity of the Ethics Commission, takes away the rights that they've had as an independent agency. And I see one thing in here where you're taking the money and putting it in the general fund when they've been using those fees in the commission. That's just one example. I have great qualms that this was something that was done at the behest of someone or a group being angry. And I think that this requires more time than we've had to be able to spend, because at this point, I would want to ask questions of the commissioner, and I want to know what the comparison is, what it does to the commission, what does it take away, what does it improve. Now, I know when he spoke, he said there are things that need to be cleaned up. There was no question of that at all. He was very clear on that. But I don't feel that this takes as much of that into consideration, and it is a body of its own, and I do think we need to respect it. They need to respect us, but this as a response for somebody who didn't like an outcome of something, I don't believe this is the right way to go. So I'll be opposing the amendment in the bill. Thank you.
Thank you, Representative. Is there any more discussion on the amendment? Okay, seeing none, I close on my amendment. Is all those in favor signify by saying aye? Aye. All opposed, nay? Okay, the ayes appear to have it. The ayes do have it. We're back on the bill. Is there any further discussion on the bill? Okay, Mr. Vice Chairman.
Yes, the I guess I'd like to respond to some of the comments just from other representatives. You know, I do think it's a fact that one of the first things that was made clear that this bill doesn't affect any ongoing investigation that currently has happened. I think it is very true with administrative hearings and I can think of specifically, I know on college campuses with some of these sort of Title IX, you know, sexual assault or, you know, harassment cases, whatever they were, but it's become a big issue. You know, just the track record of how some of these universities have handled these, where they're judge, jury, and executioner, and where people, you know, have ended up having to go to court to actually have their basic, you know, underlying rights, due process rights respected. I think here, obviously, this is a totally different type of situation, but I don't think you have any one individual case. I think if you read kind of clearly, and I spent a lot of the afternoon looking over some of the explanations given by the folks who were, whatever, asking for this, is that it's a whole series of situations that have developed over the last couple of years where there are legitimate questions, and I think just looking at it, legitimate due process questions that have come up, and I think this is a reasonable attempt at reforming the ground rules, you know, to resolve some of those concerns. And so, in that sense, I certainly support the bill.
Is there any further discussion? Okay, Representative Howell.
Thank you, Chair. I just wanted to share that as this bill was introduced, I had a lot of caution and a lot of concerns, and I spent quite a number of hours doing research and reading and making phone calls, talking to different people and entities, and as I did that, I became, and along with the amendments, I feel very comfortable that this is a good movement forward for our state. And if there are things that need further modified in the future, I believe that we can, as we see how things play out in the future and in the real world. But overall, I feel like there's a good balance in this.
Any Representative Essex?
I just want to second what Leah was saying. When the bill was first introduced, I was like, ooh, you know, I think that the amendment that was given is so, so helpful. And, you know, passing this out of committee doesn't mean action's taken. We just need a fair hearing on the floor, is my thought. There's a lot of opinions surrounding this and issues that need resolved. So bring it to the floor would be, I think, the right move.
Any further discussion? Okay, before I return to the maker of the original motion, you know, I'm sitting here looking at the great work that the research did. The Interstate Grain Marketing Commission has to go to a judge to get a subpoena. The Athletic Commission, the Department of Commerce, has to go to a judge to get a subpoena. This is so much more serious. We're talking about regulating free speech. And the idea that somebody who's subpoenaed, well, they can just go to a judge to oppose the subpoena or try to get the subpoena quashed. Well, if you're a candidate in the middle of an election campaign, the idea that you're going to go to a judge and you're going to, you know, waive a subpoena you got from ethics, you know, in front of newspapers and television cameras and say, you know, I was subpoenaed by ethics, I want this quashed. That's just, you know, that's just not realistic. And so I think that adding that additional step before such a serious move is taken, I think, is appropriate. And so with that, I'll return to Representative Bergquist. Would you like to renew your motion as amended?
Yes, I move that we pass out HB 2391 favorably as amended in committee.
Hey, Representative Underhill renews his second. You've heard the motion. All those in favor signify by saying aye.
Aye.
All those opposed, nay? Okay, the ayes appear to have it. Okay, division has been called. All those in favor of the motion signify by raising your hand and keeping it raised. Okay, all those opposed, same sign. Okay, the motion carries 8-4. Does anybody wish to have their vote recorded? Okay. So the ranking minority member wishes to have his vote recorded. Representative Neighbors wish to have her vote recorded. I'm sorry, neighbor, I'm sorry. I'm so sorry, Representative. I've been trying to train myself, and I'm just failing miserably. I believe Representative Oropeza also wants her vote recorded, as does Representative Hoagland, all negative. Okay. Seeing nobody else wanting to record their vote, we'll move on to our next order of business, which is a hearing on House Bill 2312. Mr. Revisor, could you give us a rundown on that bill?
Mr. Chairman, members of the committee, House Bill 2312 deals with amending the Campaign Finance Act. Section 1, the amendment in line 10 is a technical amendment, which one of these days we're going to get. It's in the other bill that you just passed out. The amendment, if you turn to page 3, provides any party committee that does not employ a treasurer and require such treasurer to file a surety bond shall be liable for all reporting requirements of such party committee under this section. There's a similar amendment in section 2 dealing with, again, party committee that does not employ a treasurer and require the treasurer to file a surety bond shall be responsible under this section. And section 3 is another amendment dealing with civil penalties and so on, and it provides for any violation of the Campaign Finance Act committed by the treasurer of a party committee who provides treasury services to the party committee on a volunteer basis. The commission may assess a civil fine against after proper notice and an opportunity to be heard in an amount of not to exceed $1,000, and then which is less than the up to $15,000 that's above. And there's a new subsection C, no treasurer shall be held individually liable for violations if committed by the party committee of which the treasurer is an officer. All civil fines assessed against the party committee will be against the party committee. And it's basically you don't exempt the treasurer for unlawful conduct. That basically is it. You've got a couple of conferees on the bill.
Okay, are there any questions for the revisor? Okay, so Representative Dodson.
Just to be clear here, when we're on page 5 down at, let's see, Bowlegs 2, Bowlegs 3. So the difference between those has to do with someone who either has or has not filed a surety bond. Is that the difference?
I believe that's correct. Let's, again, the no treasurer of a party committee shall be individually liable for violations committed by the party committee of which a treasurer is an officer. All civil fines assessed shall be assessed against the party committee and so forth. So I think it's intended to protect volunteer treasurers, but you will get more testimony.
So I have a question before you sit down. So does this apply to anybody besides the state party? I mean, what party committees would this apply to?
I'll let Mark handle that, but I think it's of any party committee. So I mean, that's what it says. So
okay.
I'm not clear.
Yeah.
You've got candidate committees, you've got 3 or 4 different versions of committees and so forth. And this deals specifically with party committee. So anyway.
We'll ask the conferees. Any other questions for the revisor? Okay, seeing none, thank you very much. Okay, we'll move on to proponent testimony, and our first proponent is Representative Schlingensiepen. Welcome to the committee.
Thank you, Mr. Chairman. Thank you, members of the committee, for having a hearing on House Bill 2312, for allowing me to speak to it. House Bill 2312 would exempt political party treasurers from certain violations of the Campaign Finance Act if that treasurer serves on a volunteer basis. Stepping up to serve as an officer for a party committee, I think, is a noble task that requires one to donate time, energy, and passion to a cause larger than oneself. As treasurer, one assumes an additional legal responsibility for the finances and bookkeeping of that party committee. It is common for a voluntary treasurer to serve alongside full-time paid staff members of that party committee whose primary task it is to carry out the day-to-day accounting functions, with the volunteer treasurer verifying the accuracy to the best of his or her ability. Holding volunteer treasurers legally liable for the finances of a party committee, given that they are not full-time staff and often lack the kind of in-depth accounting experience a bonded treasurer, for example, could bring to the task, makes their sole liability problematic. Should they verify financial accuracy to the best of their ability? Most certainly. Is it possible that they will miss things that only a full-time experienced accountant would catch? Very much. If there are accounting problems that need to be addressed, the party committee, rather than a volunteer treasurer, is in the best position to rectify or take remedial action with regard to whatever problems are discovered and to make whatever amends the Governmental Ethics Commission deems appropriate. This bill in no way exempts volunteer treasurers from the consequences of intentionally attempting to create false financial reports, rather only from those errors that are of a non-nefarious or technical nature. Exorbitant fines that under the current statute may be assessed for financial reporting errors could have a chilling effect on the participation of those who would otherwise gladly volunteer their time as treasurers for their political party. This bill seeks to place the ultimate responsibility for these kinds of errors with the party committee, which is the entity that has the most to gain from seeking to rectify whatever led to the errors in the first place. Thank you, Chairman Proctor and members of the committee, for allowing me to offer testimony today. I will gladly stand for questions at the appropriate time.
Okay, you're the only proponent, so we're going to go ahead and move on to questions right now. So are there any questions for the proponent? Representative Berquist.
Yes, sir. Thank you for your testimony. Would this in any way preclude someone who was a professional treasurer in another role who simply wanted to come and volunteer to be treasurer for this and hence be a volunteer treasurer? Because it seems like and a lot of times in our campaigns, in our small campaigns, we get a friend that is willing to just keep a close watch on our books and help us to get a good report through. But is there any answer for that, or is that even a necessary question?
It's a good question, but I would say the way it's written now, it just talks about volunteer treasurers, whether or not they're professionals or not. I would say if you're not a full-time, bonded treasurer in the employ of the party, I think this bill would exempt that individual from. All right.
Thank you.
Okay, is there any other questions for the proponent? Okay, so Mr. Vice Chair.
Yeah, Representative, no, I think this bill is very well intentioned. I think it makes a lot of sense, but I do know you have a bit of a tie-in with this. I mean, this sort of happened to you, and so can you kind of explain how the whole thing that brought this to your attention, if you don't mind, just sort of
no, I don't
explaining it for us?
I don't mind at all. I served as treasurer of the Kansas Democratic Party in 2016 for about a year, and learned last October maybe that an investigation had been initiated into party finances between, I believe, the years 2009 and 2016. And there, certain systemic reporting failures were discovered. And And I, of course, know that as treasurer, I'm responsible for my time as treasurer. That's not the question here, and certainly not for me. I found it embarrassing, to say the least, but that's not the point. You know, and I went before the committee, and there was a hearing, and I received a letter of, what's the word? A letter of warning? Caution, a letter of caution. I was asked to do 8 hours of volunteer service and to write letters to 10 treasurers admonishing them to be dutiful in their responsibilities, in the execution of their responsibilities. I have no problems with that at all. The question I asked myself was, what is the problem here, and who ultimately would take the responsibility for rectifying those problems? Certainly not a treasurer who's been out of office since 2016. And so it seemed to me that it would make much more sense to place the responsibility for these kinds of, I'm going to say, you know, more day-to-day kinds of technical things. I mean, I didn't catch them. Even flash reconciliations didn't demonstrate to me that there was any fundamental underlying problem, but clearly there was. And so, who would take the responsibility for that, to carry that ball forward? Past treasurers. And it just seems like rather than passing the problem on from treasurer to treasurer, there were 3 of us apparently who had similar errors, and one was exempted from responsibility because unfortunately he'd passed away. But it seems to me that the overarching entity would be much better positioned to actually take some action on this than an individual treasurer. I mean, I no longer have any skin in this game, so I could say I really don't care whether this bill passes or not. I'm not going to be a treasurer again, and the bruise has already been dealt to my honor, so you know that's fine. What's really of issue to me is how do we solve the problem, and I'm hoping that this is a step in that direction, and that's why the bill is introduced. But I certainly am open to any friendly amendments. If
one more time there, Mr. Vice Chair.
You know, I mean, I'm a small business owner. You know, it's a pain finding a treasurer just to do for a local campaign, much less a statewide political party, which is going to have hundreds of thousands of dollars of donations, and just, you know, I totally get the situation. I mean, I appreciate you very much coming up and explaining it for us.
there are things, if I may, Mr. Chair. I mean, you know, if one were obligated to record every single donation, every single one, accounting software would be able to find, you know, where aggregate contributions exceed existing limits. But short of going back and checking every single check stub, there just simply isn't any way to do that practically. So I'm just saying, you know, this is really an attempt to rectify a problem and nothing more than that. I'm simply willing to take this bull by the horns, if you will.
Representative Neighbor.
Thank you, Mr. Chairman. I know recently there was an article on a situation with the Republican Party and finding unpaid bills, and the books were in total disarray per the new elected chairman. And so would they be exempt from this, or would it be from when this goes forward? I'll ask that of Mr. Skoglund.
Yeah, that was going to be my question too, is the new vice chair of the Republican Party, former treasurer of the Republican Party, may be liable for some stuff that happened when she was the treasurer. And would this be retroactive? Would this be going forward? We'll save it for Mr. Skoglund. So are there any other questions for the representative? So I got a couple questions. Is this all levels from a county party all the way up to the state? Is it just the state? What does this impact?
I was thinking simply of the state party, but I mean, the way it's written, it obviously would apply beyond that as well. But
okay. All right. And then my next question is, are you concerned at all about unintended consequences? And my first one is, do you think if the party's on the hook instead of the treasurer, that the commission might be more likely to impose the full fine rather than do community service or whatever your punishment was? Well,
again, this has to do with the kinds of errors I'm talking about. It doesn't have anything to do with nefarious activity. It doesn't have anything to do with gross negligence of duty. It doesn't have anything to do with sort of major kind of infractions against the responsibilities, I would say. But I will stand correctly if that's the case. So I'm not really that worried about that. The
Then
scope's pretty limited.
my other concern about unintended consequences, and then I'll shut up and let you off the hook unless anybody else has questions, is there, are we creating an incentive with this bill to not use volunteer treasurers because the party doesn't want to pay the fine? Are we creating an incentive to go to a professional, accountant with the surety bond so that they're on the hook for all the money?
I hope what we're doing here is trying to just correct a problem, and whatever it takes to correct the problem, I think is fine. I think we don't want to deal with these kinds of problems in the future, and so whatever we can do to get these kinds of problems of a more technical nature, I'd say, off the table, the better.
Representative Howerton.
Thank you, Mr. Chair, and this may be a question for the reviser. I was just trying to find the definition of party committee, how it's defined. I looked at the statute. I think I did this right. I'm learning. But, so maybe he could expand that for us.
I'll let Mark Skoglund,
Okay.
who's going to testify. I don't have my computer handy, but
I'm just being handed the statute where the definition is just 25-4143.
Can you go ahead and read it or hand it around or something? Okay, all right. Okay, did you get that number so you can look it up? Okay.
25-4143.
Okay. All right, are there any other questions for the proponent? Okay, thank you very much. Is there anybody else wishing to testify as a proponent on House Bill 2312? Okay, seeing none, we'll move on to opponent testimony. I have none listed as opponents. Is there anyone wishing to testify as an opponent on House Bill 2312? Okay, seeing none, we'll move on to neutral testimony, and my only conferee listed is Mr. Skoglund, the Executive Director of Governmental Ethics Commission. Welcome back to the committee.
Thank you. I will say that I'd considered being a proponent. The only reason we're neutral is just because we typically are neutral about things that affect our responsibility, even if we think they're probably on balance positive. So my general comments here are going to be positive about the bill, but to be clear, we're neutral just because of where we typically fall about campaign finance advocacy. So to answer a couple of questions first at the right at the fore, a party committee is defined in 254143. I know two people have asked that question. It includes several things. It includes everything from the state committee down to a central committee and everything in between. So there's a number of things that are considered central committees. For example, each congressional district, a party can have a committee that is considered a party committee under the law. Things like that. But it's a 4143I, and there are 6 different categories that are discussed there that can all be considered party committees. The one that people normally ask me about is one per county. That can be a central committee. So for example, Johnson County, a lot of people live there. There's the formal central committee, and then there's a few other groups there that also do similar things, but they're technically PACs, not party committees. So party committee means a lot of different things, but it does mean everything from the state party all the way down to central committees. There's a question on when it was effective. I don't have the text of the bill in front of me, but typically the end of the bill will say one of two things. It'll either say when published in the statute book, which means it'll be effective on July 1st. I think that's probably what it says. Otherwise, it's when it's passed. I think the other one is when it's published in the Kansas Register, which is typically fairly quick afterwards. So either way, it would not be retroactive. The text isn't retroactive in any meaningful way. I'm just going to have some very brief comments. You have my written testimony that explains a bit more. The first is that party committees do occupy kind of a unique space with respect to their treasurers. Obviously, as candidates, you all know that you are very lucky to have treasurers who are willing to support you in your campaign, and most of them are not paid either. But in party committees, unlike candidates, the only person who is liable for a party committee report is the treasurer, according to statute. There's no one else, the chairperson is not liable for them, there's no one else in the party committee. Candidates, you all know, you're liable for your own reports as well. There's also some other reasons why party committees are unique. I discussed some of them in my testimony, but there's a reason why party committees are being handled kind of uniquely here. 2312 really does a few things. Any civil fine related to reporting are the responsibility of the party committee. If a volunteer treasurer has a violation of the Campaign Finance Act, the maximum fine is set to $1,000 every time instead of the normal $5,000, $10,000, $15,000 structure for first, second, third, and further offenses. And third, volunteer party committee treasurers are exempted from liability for any violation that was actually committed by the party committee. So if the party committee had done something that resulted in a treasurer inadvertently causing a violation, the party committee is the entity who should be held responsible for that, and that's how the bill addresses it. I will note that I have a suggested amendment. It may be friendly, I think, but I'll have to see what the author indicated or intends here. There is on the fine cap, setting the maximum fine at $1,000. That's for any violation committed by a treasurer, a volunteer treasurer of any kind. I think the intention is to restrain that to reporting violations. So if there's any sort of reporting issue that the treasurer has committed, then that would be subject to only a lower civil fine. There's no universe that could be assessed over $1,000 per instance. So that would replace any violation of the Campaign Finance Act with the specific statutes that are about reporting, typically 4148, and that the ensuing statutes that are related to that. So as opposed to if a treasurer does some sort of other activity that is also a violation of the Campaign Finance Act that is otherwise spelled out in law, they shouldn't be exempted from that as well. So that'd be my recommendation, but otherwise I'm neutral about the bill and can answer any questions that anyone has at the appropriate time.
So I actually have a question. I'm sorry. I just want to clarify first, and then I'll get to you, Revisor Heim. The $1,000 fine for the treasurer under this bill would be charged to the party committee if we pass this bill?
So the way that it's worded is that if a volunteer treasurer committed to violation of the Campaign Finance Act, then the maximum fine would be $1,000. If the party committee commits a violation, then they can be assessed the normal fine range. Otherwise, however, and this is why there's kind of three different things the bill does. There's a separate issue that the reporting requirements, the entity that's responsible for reporting, for filing reports, is the party committee rather than the treasurer itself, unless a treasurer is paid, employed, bonded, et cetera.
Okay, are there any questions for the comfrey? Representative Neighbor.
Thank you. My husband will like that. My question is, okay, we know from the articles on the Republican side that they had problems, and they have stated that they've self-reported. So with that case being open, I would imagine it's open. I don't know that you can say anything, but would they fall under this or not? They would fall under the current rules?
So my understanding is that there's been some to-do about an error and omission notice that was sent to the treasurer of the state Republican Party. These error and omission notices are fairly conventional. I think we sent 39 of them in July alone to parties and PACs. If I remember right, the underlying issues were a couple of contributions that didn't show up and just some additional reporting issues. These are fairly standard issues. They're not complaints, they're not hearings, they're nothing like that. It's an error and omission notice that I'm sure some of you have gotten error and omission notices as well, and I'm sure you roll your eyes the moment that you see that mail show up in your mailbox, but we're always there to help fix those reporting issues. There is a civil penalty that was assessed, that happens automatically by operation of law. Civil penalties are late fees, essentially when a report is not filed timely. That's really all that comes down to. But yeah, those are issues that occurred previously. This bill does not interact with that in any meaningful way.
You still have supervision over that then?
That is something that happened previously. That's correct.
Thank you, Mr. Chairman.
Are there any other questions for Mr. I'm sorry, Revisor Heim, you've been trying to get in there and I've blown you off. I apologize.
I really don't have a question. I'm going to make a clarification. A bill is not retroactive unless you specifically have a provision in the bill saying it's retroactive, with the exception that if it's a procedural kind of a thing, then a court may interpret procedures to be retroactive. In this particular case, I don't believe it would be considered that, so.
Thank you, Mr. Heim. Is there any other questions for the conferee? Mr. Vice Chairman.
Thank you, Mr. Chairman. So, Mr. Skoglund, just for clarification, on party committees, you have the state level, you can have district level, and this applies to county level as well? For, am I understanding you correctly, that party committee, so, okay, so like, you know, Sedgwick County, Reno County, whatever, it would apply to that, okay. Also just, I mean, we're aware of sort of these recent issues, but have, like, going back over the last 10 or 20 years, I mean, is this fairly, how often do you end up with these $5,000 and $10,000 fines? I mean, has this, you know, it happens fairly regularly? I would presume you have some sense of the history of past problems.
Yes, fines that are over $5,000 typically are relatively rare and only would occur in fairly severe cases. I can only think of 3 off the top of my head. There's one that was in an instance where a campaign fund was spent improperly in a number of different personal use cases. This is quite a while ago at this point. And there were 2 other more recent cases, one with a circumstance of commingling and improper use of campaign funds, and then another one that was a situation where there was an unregistered lobbyist who had been engaging in lobbying for quite a while. Now, other than pretty severe cases, we don't see very large fines coming out of the commission. What I will note, though, is that typically when you have a failure to file issue, which is 90% of our fines, the way the commission, most of the time, it's not impossible that the person responsible does not show up to the hearing. And this happens pretty conventionally because at the time when we have a hearing, it's been months after that deadline has passed. We tried to contact them a number of different ways, and they mostly have ghosted the commission. So at that point, we end up in a situation where they don't show up to the hearing. The commission assesses a fine, which usually is $5,000 with a substantial reduction if they file the appropriate report and pay the reduced amount within usually 30 days. So that's the time that we usually see those $5,000 fines come down.
Representative Dodson, did you have a question? Okay. Any other questions for the conferee? So on the, you know, kind of on the point that we've been discussing for a couple weeks now, that, you know, money is speech, right? And when you assess a fine to a political organization, you're taking away some of their ability to speak, right? Because they can't, when you're taking money from them, you're taking their ability to do something else like mailers or whatever. Is there, you know your commission better than I know your commission by several orders of magnitude. Do you think that they might, because the fine's being assessed to the party rather than to the individual treasurer, do you think that there might be an unintended consequence of this, that they're more likely to assess a fine?
That's entirely possible, yes, that the fine may be larger if assessed against a party committee rather than an individual. I think that is definitely a concern that is worth having. I will note that the commission typically is understanding of circumstances. I won't speak on behalf of the commission in terms of what they thought in the recent hearings involving a couple of treasurers who had some reporting issues. But my understanding of that conversation was that they believed that the responsibility for those errors should not have fallen on the treasurer, but rather to the committee because of the way that those errors actually arose, or at least how they were discussed in that hearing. So I think in that particular instance, I think that if party committees could be assessed a fine, I think it's very, very likely that the fine would have been higher on the party committee itself rather than the individuals. Under statute, only the treasurers could be held liable. The commission seemed to indicate that they did not seem to believe the treasurers held responsibility for that, but that they were perhaps not directly at fault for the situation that they were in.
And I've got one more question. So do you think that it's also a potential, and it's kind of the same question that I asked the proponent, do you think that a potential unintended consequence of this is that party committees would be more likely to go get a professional bonded accountant to be their treasurer just so they don't get fined?
Honestly, it's possible, but really there's two competing rationales here, right? On one hand, the party committee, if they're more likely to go get someone who is an actual accountant who's bonded, and they're willing to pay them to do that, they're frankly less likely to have reporting issues in the first place. But the flip side of that coin is if a party committee, and typically we're talking central committees here, which is why I'm glad actually that the bill does extend to central committees. They have volunteer treasurers who run into problems, who are, sometimes the central committee hasn't been active for quite some time. Those are situations where they're not likely to be able to or want to pay in for a bonded treasurer. So I think that it's possible that the actual state party committees might head that direction. I think you could make an argument that some committees may decide to do the flip side of that, that they would have a volunteer treasurer, just because then it makes sure that they have oversight over the process rather than having it be just one person. I hope that some people are more likely to have accountants, but I don't think that the actual effect is going to be very substantial.
Are there any other questions for the conferee? Okay, seeing none, thank you very much. I don't have any other neutrals listed, so is there anybody else wishing to speak as a neutral to House Bill 2312? Okay, seeing none, I'm going to close the hearing on House Bill 2312. So committee, I mentioned at the last meeting that if there was unanimous consent, we might consider suspending the rules to work this bill. I personally have some reservations. I appreciate the bringer of the bill, and I'm glad we had this conversation, but I've got some reservations. But I'll throw it to the committee. How do you feel about working this bill today? Representative Neighbor.
Mr. Chairman, what are your reservations?
Well, I heard the neutral conferee say that he had amendments that he would like to put on the bill, and I'm not always, especially in something that's sensitive, that amenable to just bringing a amendment on the committee that the reviser hasn't even seen. But also, I am a little concerned about some of those unintended consequences I talked about, especially on, there's a big difference between a county party and a state party. A county party, the number of contributions a county party receives versus the number of contributions a state party. And when I first saw this bill, I thought it was just the state party. So those are kind of my reservations.
Do you also have may I ask another question?
Yeah, but please.
Do you also have a reservation about the amount of money? Because I think I heard that in questions that were asked. And if we're going to, and I just will throw this in, if we're going to have consequences for inappropriate actions, then there have to be, if we do something wrong, there's a consequence, whether we're 5 years old, whether we're 40 years old, or as old as I am, God forbid. And so I'm wondering if we're placing more attention on what that consequence may be rather than looking at what the problem is. Because, if somebody has done something wrong and now we want it just to fit a certain scenario, I think we're locking ourselves in because we've got two parties, we've got multiple groups, and at the same time, each one can be charged more or less depending on what they did. And so I find that this is a worthwhile bill that actually protects the treasurer for things that other people are doing that may get them in a world of hurt. So that's a lot of money.
I absolutely agree with everything you just said. Really, kind of my reservations are more technical in nature. I was kind of talking sidebar to the vice chair here while we were here in testimony. I think another alternative is to make the chairman of the party more responsible in a political, party committee, making the chairman responsible as well. I'm kind of surprised to hear that the chairman's not on the hook at all responsibility for oversight of his executive committee and the financial operations of a party. I just think that there are some things that need to be in the bill that we're not going to be able to get in the bill today. Revisor Heim reminded me that we might try to get this bill blessed and continue to talk about it after. It's not that I don't want to work the bill, it's just I don't think that I'm ready today to pass this bill out of committee as it is.
If it's possible, I would like to at least see it blessed so we can finish talking about it. If we don't do anything with it, that's fine, but it's another opportunity for us to bring, more people into the fold. I say that by protecting them from fear of you're going to come and charge me, or I'm going to be in trouble and I'm doing this on my time and with the best knowledge that I have, because it's hard enough for all of us to find somebody that wants to sit down and do that each time. And I think it's our responsibility to make that easier rather than more difficult.
I think we're in violent agreement here. It's a problem and it needs to be fixed. So, but is there any other thoughts on this? Representative Dodson.
Yeah, I think I had the same reservations that you expressed, Mr. Chair, and that is that there's quite a difference between, at least in my county, what they might do and what they might bring in and the kind of accounting they have to do versus what we do at party committees.
All right, Representative Howell.
I think, thank you, Chairman. I would agree with all the previous statements and just say, I think that allowing the state party committees and the counties committees all have some weigh-in and time to contribute to this discussion of the possible unintended consequences, and to include the director of the KGEC and maybe come to a consensus of what kind of amendments might need to be brought so that we are getting a full picture of what needs to be done to actually address the actual issue, and so that we can all be more successful in following the law in the future.
Are there any other discussion on House Bill 2312? Okay, I think committee, I think what we'll do is I'll try to get this blessed. I may reopen the hearing so that we can get more conferees in to talk, because it would be very valuable to hear from the major parties on how they feel about this. I appreciate the bringer of the bill for opening the can of worms. It's a very interesting can of worms, and I look forward to fishing. So with that, committee, is there anything else for the good of the order? Representative Berquist.
Then the goal of getting that blessing would be for us to be able to even have some discussionary meetings in the coming weeks. Is that correct?
Yeah, exactly. We may decide we want to reopen the hearing and then work the bill, after we've had a chance to consider some amendments to the bill.
Thank you, Mr. Chair.
Okay, is there anything else for the good of the order? All right, committee, so we're getting ready for turnaround here. We're going to have a week or so where we're not in committee. So I would just like to thank all of you for all your hard work, your civility, and the great conversations that we've had here in the room. And thank you, and we are adjourned.